academic and journalist, and moderating the session on behalf of the organizers, Just Peace Advocates and Canadian Foreign Policy Institute. It is so heartening to see the large number of people who have signed up for this seminar tonight, even if it's under the most deplorable of circumstances. We know as advocates and organizations, we've so often been in a position of scrambling to understand the international law that has so often been deployed against Palestinians, so that even advocating for the most basic rights and justice for Palestinians is represented as somehow impermissible or terroristic. We also know that as legal scholars and legal experts, so many of us have been doing highly intensive work trying to produce legal analyses that are responsive to the current unfolding, ever more atrocious situation. And so we thought that it would be a good idea perhaps to bring everyone together in this forum here tonight to learn about and ask questions about the international law relevant to the situation in Palestine, to build our capacity to deploy international law in our advocacy for Palestine, and also to think and strategize collectively about how we do this most effectively, including given the limits of international law itself. I am so deeply grateful to all of our legal experts here who have made themselves and their expertise available to us tonight. In addition to all of the very prominent public-facing work they do, they have also been very, very involved behind the scenes, supporting the advocacy constantly. And so I have my deepest love and regard for them, and I'm so delighted that they are here with us tonight. We're going to start with some opening remarks from three of our international law experts: Michael Lynk, the former UN Special Rapporteur on Palestine; Leilani Farha, the former UN Special Rapporteur on Housing, particularly relevant given the widespread destruction of homes and homelands as a mode of genocide in Gaza; and Neve, who is a senior fellow at the Graduate School of Public and International Affairs at the University of Ottawa, and also teaches law at the Universities of Ottawa and Dalhousie. So we'll start with some brief opening comments from each of them, and then I'm going to put to them some questions going over some of the basic international legal framework that's vital for understanding Palestine from the perspective of international law. And then we're going to turn to our three other legal experts who have so very kindly joined us here tonight for some comments on the Canadian context. We have with us Dania Majid from the Arab Canadian Lawyers Association, James Yap from Canadian Lawyers for International Human Rights, and Asaf Rashid, International Center for Palestinian Rights Canada. And all of these organizations are also co-sponsors of tonight's event. All have been doing such tremendous work on the ground, and so this event is also to celebrate and honor them, as well as to learn from their expertise. And then we'll open it up to questions from the floor. But throughout, if you have questions, please do continue posting them in the Q&A, perhaps not the chat, since that can get a little full. Post them in the Q&A, and if they're relevant to the questions during the moderated discussion, I'll fold them in as well, so that we can be as efficient as possible and get to all of your questions. And so we'll start with some opening comments from Michael Lynk, former UN Special Rapporteur on Palestine.
Actually, I think there's another order, so I think let's let Leilani go first.
Oh yes,
Alex
sorry,
go second, and then I'll tie it all together.
Oh, okay, very sorry. Leilani Farha, former UN Special Rapporteur on Housing.
Thanks, Aziza. Good evening, everyone. Thanks to Aziza and Karen for hosting this very important event. I am Leilani Farha. I am Lebanese Canadian, a guest on unceded Algonquin and Anishinaabe territory, born of a family whose farmlands were taken by the State of Israel in 1948 with the support and under the protection of Great Britain. I was asked to set the stage for tonight's discussion. This requires me, at least for the next few minutes, to somehow emerge from and bring some coherence to my rage, my sorrow, and my deep pain for what is unfolding on Palestinians in Gaza and in the occupied territories and in the diaspora. I hope you'll forgive me if I fumble, if there are omissions, if I can't tell the whole of it in the next few minutes. So the question I keep asking myself is, where are we? And how did we get here? The last 118 or so days since Hamas's brutal attack on Israel, resulting in the killing of 1,200 Israelis and the taking of more than 200 hostages, have been an utter horror show. Words are, in fact, inadequate, but here's what we are witnessing. Brutal massacres, killings, and executions of civilian Palestinian women, men, children, journalists, doctors, healthcare workers, UN staff, teachers, poets, the arbitrary detention of Palestinians, massive destruction of people's homes, and with it their identity, memories, histories, displacement and ethnic cleansing of almost the entire population, the bombing of safe spaces, the desecration of graves, massive destruction of universities, schools, hospitals, cultural sites, and businesses, severe restrictions on desperately needed aid, and the intentional starvation and dehydration of Palestinians. Palestinian children are drinking from dirty puddles. The cutting off of electricity and telecommunications, the lack of access to anesthetic, children dying from pain itself, preventable diseases spreading, women's reproductive health being severely compromised. And meanwhile, we're watching Israeli officials making public declarations dehumanizing Palestinians, declaring that Gaza will be turned into a parking lot, and making plans to establish Israeli settlements once the strip is emptied. What we see unfolding before our eyes in real time is plausibly genocide. Of course, this did not start on 7 October. Some would say it started 100 years ago, others in 1948. The foundation of today's horror show is based in an incremental genocide that began as a settler colonial project based in an ideology called Zionism, which was imposed on Palestine and Palestinians when their lands were taken from them and given to Jews predominantly from Europe, having suffered a genocide in World War II. The takeover of Palestine was sold on a fictitious claim, a land without a people for a people without a land, and thus resulted in the brutal displacement and dispossession of approximately 750,000 Palestinians, known as the Nakba, or catastrophe, the creation of the State of Israel, and eventually the occupation by Israel of Palestine. Since then, Palestinians have been permitted to live on slivers of their original lands in the harshest of conditions, conditions which constitute apartheid, as determined by many international and Israeli human rights organizations, as well as by the UN. Under Israel's occupation, Palestinians, including in Gaza, have been denied every fundamental human right: civil, political, social, economic, and cultural, and have been subject to constant violations of the Geneva Convention. Properly understood, this history has been a long and purposeful march through policies, laws, and acts toward genocide. I'll just conclude, because I'm short on time now, with some personal observations. I have worked sporadically in the OPT since about 1994, and I have used international human rights law and mechanisms throughout my career. But in the last 100 days or so, I think I've learned more than in the last 25 years of work. I have learned that most Western nations, and certainly including Canada, are beholden to Zionism. I have learned that the UN system is even more impotent than I thought and is also beholden to Zionism. I have learned that without the enforcement of international law, there are no red lines where Palestinians are concerned, that states are quite willing to be complicit in genocidal acts. I have learned there is no safe space or place for Palestinians. But I have also been astonished to learn what world leaders refuse to. And for this to be apparent in my lifetime is kind of mind-blowing. I have learned that most of the world believes in humanity and in the liberation, self-determination, and the equal and inalienable rights of Palestinians. Thank you.
Thank you, Leilani, for those powerful comments situating the spectrum of absolute horrors and violations unfolding in Gaza at the moment in the context of the structurally genocidal, settler colonial nature of Israel's project in Palestine itself, and reminding us of the context of genocide that underpins our own presence on these lands that are currently referred to as Canada. Now, Alex Neve.
Leilani, those are powerful words to follow. My name is Alex Neve, and I'm joining as well from unceded Algonquin Anishinaabeg territory, and I'm acutely aware of how significant that is as we come together for a session to talk about dispossession and genocide. I have one word around which I want to really organize my comments, and that word is impunity. One of the most significant barriers to human rights violations, and certainly one of the most obvious causes anywhere of ongoing gross and systematic human rights violations and abuses. And it's evident as to why that's so. If there are no consequences for committing human rights violations that are so grave and serious as to amount to crimes under international law, then how or why do we even expect that the violations will come to an end? Without justice, without accountability, it's almost certain not only that the violations will continue, but more to the point, and that's what's in front of us right now, they will worsen and deepen. And that's why, and I think many of us come from years and decades of work in the human rights movement, and we know that from the earliest days of research, of advocacy, of campaigning, of legal challenges, there's long been a prioritization of that demand, of that need to pierce through that impunity that shields perpetrators of genocide, of war crimes, of crimes against humanity, and other crimes under international law. And for so long, for decades and decades, in fact, that was an absolute illusion. We demanded it, of course we did, but we had no illusions that it was actually going to happen. At best, some states might be inclined to take some action at their own domestic level, but only if there'd been a change of regime or government such that pursuing justice was actually more about penalizing and attacking opponents. And there was nothing at international level to step in and ensure justice when there was that failure of accountability at national level. That began to change in the 1990s. We had special courts convened by the UN for the former Yugoslavia, for Rwanda, for Sierra Leone, for Cambodia. And then, of course, 1998 brings the creation of the International Criminal Court, which then gets established and start hearing cases as of 2002. There's a long way to go, but the world has agreed that justice is key, in particular to preventing, ending, and redressing grave human rights violations. And the international laws and institutions to deliver that justice now exist. So that's broad context. What of Israel-Palestine? If one was to search through keywords in the hundreds and hundreds of thousands of pages of reports, resolutions, findings, declarations, even if we were to just limit ourselves, I don't know, to the last 25 years, emanating from UN bodies like General Assembly resolutions, the outcomes of commissions of inquiry, international human rights groups reports, Israeli and Palestinian human rights groups reports, all of which, of course, have detailed the unrelenting war crimes and crimes against humanity committed against Palestinians by Israeli forces, particularly in the occupied Palestinian territory, but not only. Including violations, and we've just heard this from Leilani, associated with the toll of unlawful occupation, apartheid, unlawful detention, torture, ill treatment, and of course the extensive war crimes committed during military campaigns in Gaza and southern Lebanon. And it's important to note and recognize here that those concerns and those reports have spoken of this has also extended to war crimes and crimes against humanity, for instance, associated with rocket attacks by Hamas and other armed groups against Israeli civilians. So we put all of that together. We do our massive keyword search, and there is no doubt that the words impunity, justice, accountability would rise to the top of that list. And that's because those reports have become a disgraceful catalog of impunity prevailing over justice, no matter the extent of the violations or the gravity of the harm. And the more that continued, the more it was assured to not only continue, but to worsen. And so everything that has brought us to this terrible moment, the horrors of the attacks on October the 7th and the agonizing and harrowing toll of, I think Leilani was saying 118 days now of genocide, is so deeply ingrained with those years and decades of staggering impunity for what have been such obvious and glaring crimes. Now, that's not, Israel and Palestine isn't unique in this world when it comes to impunity, but what does stand out, because we see it everywhere, but what does stand out with respect to Israel-Palestine is how long it has gone on. For decades and decades, since the Nakba, since the occupation, since the blockade of Gaza, since the international recognition of apartheid, no matter how much worse the situation has become, there has always been impunity. And impunity in the context of a situation that many have observed is probably one of the most documented and researched situations of grave human rights violations that exist in the world today. So it's not for lack of information, it's not for lack of knowing, and it's not for a lack of an extensive period of time in which to take action. Meanwhile, we had a new player in town. The International Criminal Court gets underway, and one would have thought and assumed the moment is here. Finally, we can look forward to an institution that will deliver justice. But of course, that too has not yet been the case. Its efforts are opposed by Israel itself, by the United States, even by Canada, the great champion of the International Criminal Court. So, not surprisingly, be it with respect to the situation in Israel-Palestine or more widely, frustrated around the constraints and failures to ensure real accountability, particularly in the face of massive human rights crimes like genocide. We've suddenly seen in the last few years a renewed interest in a global judicial institution that for years and decades has really been overlooked and hasn't played much of a role in responding to violations and upholding human rights. Enter the International Court of Justice. Gambia versus Myanmar in the Rohingya genocide. Ukraine versus Russia, the genocide in play there. Canada and the Netherlands versus Syria for widespread and systematic torture. Not a surprise, therefore, that South Africa follows that avenue to potential justice at a time of such grave concern, and does so by invoking the Genocide Convention. Did so because the longstanding and entrenched contemptuous disregard for justice cannot go on. Did so because justice certainly cannot be ignored when the ultimate of international crimes, genocide, is underway, with the clear obligation shared by all states to take action from both to prevent it from occurring, prevent it from worsening, and certainly to end it. Now, South Africa has been much criticized by many states for doing so, by the Israelis, by the US, by Germany. Canada's repeatedly ducked the questions with unbelievably convoluted contortions of expressing support for the court, while stressing that doesn't mean we support the premise of South Africa's case. But the obligations that arise by way of the Genocide Convention, known in legal terminology as erga omnes obligations, which is a archaic Latin way of something saying very beautiful and important, and that is towards everyone. South Africa has embraced that responsibility, has been pilloried by many for doing so. But I think we would all agree that what we say to South Africa is thank you at long last. And now I'm going to turn it over to Michael, who's going to actually take us to the main event.
Thank you, Alex, for reminding us that impunity is not a mere passive absence of justice, but actively constructed to shield egregious state violence, and that the task of bending the arc of the moral universe towards justice requires tremendous energy and effort on this terrain of struggle that is international law. Now, Michael Lynk to take us through this landmark International Court of Justice decision.
Thank you very much for having me, and I deeply appreciate the chance to briefly describe what the International Court of Justice did last week. And I'll try not to be too lawyerly in going through all this. I read the ruling, if you wanted a snapshot, as a glass 3/4 full. This was a tremendous victory for South Africa, for the Palestinians, and really for the global South. And I think we see, as always with respect to the question of Palestine, the fissure mark between the global North and the global South, and how they viewed the decision, how they reacted for or against it, and what's going to happen going forward. Now, the issue before the court was the genocide application brought by South Africa. But what the court heard almost 3 weeks ago in terms of arguments, and what it delivered last week in terms of its ruling, was on a request by South Africa for what are called provisional measures, which we would know in Canada as an injunction to try to keep to stop violations of or potential violations of the Genocide Convention until the matter goes to a full hearing, a full trial in front of the International Court of Justice, the highest court in the UN system, sometime 3 or 4 years from now. So that the bar was whether or not South Africa could prove on a plausible case whether there was both genocidal acts and genocidal intent as being possibly committed by Israel during the past 3.5 months. And South Africa submitted an 84-page application at the very end of December. I've got to say, as a lawyer, I've rarely ever seen a document that is rich in evidence, as well written, and as deeply compelling as what South Africa presented. This really was a model of legal advocacy. And we saw that repeated in the heroic stands taken by the South African lawyers, the lawyers acting for South Africa 2.5 weeks ago in front of the court. What the International Court of Justice said in sum is that South Africa made out its case that there were plausible acts of genocide being committed, what lawyers would call the actus reus. And what it did was quoted a number of UN documents and statements made by the UN Secretary General, made by a number of UN organizations, including UNRWA, the embattled UN agency that supports Palestinian refugees. And it wound up saying that in the end, after reviewing a number of these statements, it said, in these circumstances, the court considers that the catastrophic humanitarian situation, the court's words, are likely to experience complications, and therefore it's persuaded that on the facts presented by South Africa and documented by the UN, South Africa made out its case on the possibility of genocidal acts. It had to prove also intent. And what it did was review the over 60 statements made by South Africa in its application of quoting of senior Israeli political and military leaders, indicating or displaying extremely dehumanizing language directed towards the Palestinians. Gaza will be flattened. There'll be nobody left in Gaza. It's going to be a desert by the time we're through. And what they actually quoted in their decision were statements, three statements, one made by the president of Israel, one made by the Minister of Defense of Israel, and one made by the now Foreign Minister of Israel. And the Foreign Minister of Israel, the now Foreign Minister of Israel, is quoted as saying, all the civilian population in Gaza is ordered to leave immediately. We will win. They will not receive a drop of water or a single battery until they leave the world. So with all that taken together, the court then agreed with South Africa, and it issued a series, I think, of 6 legally binding provisional measures, injunctions. I won't go through all of them, but the most important ones are, number 1, it ordered that Israel must do everything within its power, its words, to stop the commission of acts that might be violating the Genocide Convention, which included the killing of Palestinians, the causing of serious bodily and mental harm to the Palestinians in Gaza, and to stop deliberately inflicting on the Palestinians of Gaza conditions of life calculated to bring about its physical destruction in whole or in part. It also ordered Israel to allow humanitarian aid into Gaza to the degree required to meet the needs of the population of Gaza. It also ordered Hamas to release all of the remaining Israeli hostages. What it did not do, and why I say the decision is 3/4 full, it didn't order a ceasefire. And now I think South Africa made a very good point when asked about the meaning of the decision. Excuse me. It said, look, if Israel is going to obey the provisional measures issued by the court, such as stopping the killing, stopping the civilian harm, allow humanitarian aid in, it's going to have a ceasefire. And it cited a number of senior UN officials as saying there's no way that we can meet anything more than the minimum needs of humanitarian assistance needed by the Palestinians in Gaza unless there's a complete ceasefire, unless there's a cessation of hostilities. Alas, what Israel very expectedly has stated, they look at the glass 1/4 full. So does the United States. So do some countries in Europe, and basically say Israel is allowed to continue its operations as long as it keeps on obeying international humanitarian law. And this is what we've heard continually from countries in the global north. You know, we're distressed by the number of Palestinian casualties in Gaza. We're distressed by the suffering of Palestinians in Gaza, and we're urging Israel to obey international humanitarian law. It's long since past time that just keep on calling them to obey international humanitarian law. Call them out for the violations. Call them out for the indiscriminate killing of Palestinians, even as admitted on 2 occasions by President Joe Biden. Call them out with respect to the use of starvation and the denial of fuel and water as a crime against humanity. The use of starvation against civilians in a conflict zone is absolutely a violation of international law. Call them out with respect to the deliberate denial or obstruction of humanitarian aid getting in. Now we have somewhere between 500,000 and 700,000 Palestinians who are in a famine situation. 80% of the population of the world right now that is facing starvation are living in Gaza. These are harrowing figures that we rarely ever hear in Canada, and certainly not from the lips of our political leaders when asked about questions on Gaza. And I'm afraid not really very much from our mainstream media as well. And the last thing I'll say is Canada, as was mentioned, said in the aftermath of the decision that I think it was a statement made last Friday by Minister Mélanie Joly said, "Our support for the ICJ, the International Court of Justice, does not mean that we support the premise of the case brought by South Africa. It is for the ICJ to make a final decision in the case, which it has not done today." Curious, in 3 decisions made by the International Court of Justice, where they issued provisional orders over the last 2 years, Canada joined statements with other countries. Let me just give you quick examples. With Myanmar in 2022, after provisional measures were issued by the International Court of Justice on the charge of genocide, it issued provisional orders exactly the same as were issued against Israel. What did Canada say in those circumstances? Joining other countries, it said, "We reiterate that Myanmar must comply with the ICJ's provisional measures order." With respect to Ukraine and Russia, also in 2022, Canada joined with other countries in the aftermath and said, "We welcome the ICJ's rulings on provisional measures and strongly urge Russia to comply with this legally binding order. The ICJ is a pillar of the rules-based international order." And with Syria, in November of 2023, Canada issued a statement together with the Netherlands with respect to provisional orders issued by the court on the charges of torture by the current regime in Syria. And they said, "We welcome this decision of the court to indicate provisional measures. The order issued today is binding on Syria. It must now immediately implement these provisional measures." Show me the daylight there, because there's lots of daylight between what Canada said on those 3 circumstances involving provisional measures and what it said with respect to Israel. What it said with respect to the order against Israel is, we're going to wait for 3 or 4 or 5 years down the road on the final decision by the court, and then maybe we'll express a little bit of concern with regards to this. Why the difference in all these cases?
Thank you, Michael, for taking us so clearly and expeditiously through the ICJ's decision and cutting through so incisively the hypocrisy and double standards in the global North states' responses to the decision, and also their legal obfuscation and constantly upholding the chimera of Israel, prospectively upholding international humanitarian law with respect to Palestinians as a quote-unquote solution to the situation. Now we're going to go through some questions that go over more broadly the international legal framework and terrain that's relevant for discussing Palestine and international legal terms. We already have very many questions in the Q&A. I'll fold some of them into the discussion as we go along, but don't worry if we don't address your question in this portion. We will also have open Q&A later with all of our legal experts. So if we don't get to it now, we will get to them then. And for people who are wondering specifically about legal actions and other actions that can be taken in Canada, we are going to have that addressed by Dania, James, and Asaf in the next section. So first, let's start with the implications of the ICJ ruling itself. Michael, you described some of the provisional measures that the court ordered, which are legally binding, but in the absence of any enforcement mechanism, do these really have any meaning, particularly when we know any efforts to enforce them through the UN Security Council would be vetoed? And also, what about the current situation on the ground in Gaza, which indicates that the provisional measures have already been being violated, for example, with the participation of many Israeli ministers and politicians in a conference explicitly inciting genocide in contravention of the provisional measures? Are there any repercussions for that?
Sure. I'll be very brief with respect to this. I'm sure Alex and Leilani also have very good insights as well. International law by itself won't liberate Palestine. It won't bring about justice in the world, but it is an important political, legal, and moral marker for us. It's international law combined with international resolve that will wind up enforcing the rights and obligations and responsibilities that are inherent in international law and the system we've created over the last 80 years. So you're right. The provisional measures ordered by the court this past Friday are legally binding. The court said that expressly at the end of its ruling. This means that the issue now goes to the UN Security Council. There was a meeting today called by Algeria at the UN Security Council. A number of every country spoke about the ruling, and you can tell the tenor between the countries in the global south and the countries in the global north as to how they regarded what the ICJ said. But the long and the short of it is, I expect another ceasefire resolution to be introduced at the Security Council very shortly, based on what the court ruled. And then the US will be in the position of deciding whether or not it's going to issue a fourth veto of a ceasefire resolution since this war began. Keep in mind that the last time the vote was held at the Security Council on the 22nd of December, the vote in favor of an immediate ceasefire was 13 in favor, 1 abstention, the United Kingdom, and 1 vote against, obviously the killing vote from the United States. On December 22nd, we had just passed 20,000 dead in Gaza, according to our best official figures. We're now at 27,000 dead 6 or 7 weeks later with respect to that. So is the United States going to turn around and issue a fourth veto with regards to this? It realizes that Israel's reputation is sinking fast. It realizes that its own reputation is sinking fast internationally. It also recognizes that it's alienating important parts of the kind of democratic coalition in the United States as we enter into a presidential election year. Arab Americans and Muslim Americans are almost entirely opposed to the Biden support for the ongoing war in Gaza, particularly in key swing states that the Democrats need to win in November, such as Michigan, Wisconsin, and Pennsylvania. We also know that among voters under the age of 35, the war in Gaza has drawn their overwhelming opposition and their real distaste with respect to what the Biden administration's policy has been with regards to this. Doesn't mean they're going to vote for Trump. They may vote for a third party, or they may not vote for all. But whether or not the Biden is going to be able to recover and seek to rebuild that coalition after its diplomatic shield for Israel over all this time is something we're going to have to wait and see with regards to this. The last thing I'll just simply say on this: the United States, since 1973, has issued 85 vetoes as a permanent member of the Security Council. That's almost twice as many as the next number of vetoes issued by the combination of the Soviet Union and Russia in that period of time. Over half of those vetoes, around 45 or 46, have been vetoes protecting Israel. And of that, 32 of the vetoes have been directly expressed to protect Israel's occupation of the Palestinian territory. So this has been the reason why we don't have a two-state solution today. This is the reason why Israel can continue to act with no cost and acting with impunity with respect to the conduct of its occupation, the conduct of its wars, and the conduct of its subjugation of the Palestinians.
Thank you, Michael. I'm going to ask Alex and Leilani if either of them would like to say anything about that. But first, I'll fold in a follow-up question that we have from the Q&A, which is, if the Security Council is an obstacle, is there anything that the General Assembly can do to honor and bring life and actualization to the ICJ decision?
Sure, I can jump in. I mean, certainly the General Assembly can take it up, and we have seen, especially in the early days, as the Security Council was consistently being thwarted by the U.S. veto, that the General Assembly did take it up, and of course that's where those important resolutions about a ceasefire were being debated, and where Canada, of course, initially was abstaining quite scandalously on those resolutions, and then towards, I think, the end of November or early December, came on board, although hasn't really done much to give life to our change of position on that resolution. So yes, it would be possible, once again, for the General Assembly to turn its attention to the situation, including with particular attention to the International Court of Justice ruling. As was noted, though, throughout the fall, the difference between the Security Council and the General Assembly in terms of international law is the Security Council is binding and, most importantly, has actually legal powers under international law to even impose sanctions, etc., and take that kind of enforcement action, whereas the General Assembly doesn't. Does that mean it would be pointless or meaningless to take this to the General Assembly? No. I think anything that once again would give a forum in which to show how many states, and I think it would be extensive, are prepared to line up behind the ICJ. I mean, we've even have heard it, not from our own government, but we have heard it from other governments who have said they explicitly disagree with South Africa's case. Germany is the example everyone's been using, but has nonetheless said the ICJ has ruled it should be respected. So I think it could be kind of surprising to see where the votes fall out in a General Assembly resolution, and that could have some persuasive value.
What exactly does respecting the decision mean on the part of third-party states? Does the court's finding that Israel is plausibly engaged in genocide have any implications for the complicity or triggering of the obligation to prevent genocide on the part of other states? For example, we have a question in the Q&A about whether arms trades to Israel could now be in violation of the ICJ's measures, provisional measures. So what are the implications for states not explicitly named in the judgment? Alex.
Well, maybe to give it a bit of a concrete focus, how about let's think of what it means for Canada. So Canada has been a party to the Genocide Convention for over 70 years. We ratified it back in 1952. And it's worth reminding ourselves of what the first article, Article 1 of the convention actually says, and it is that the contracting parties, which includes Canada, confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law, which they undertake, that's a kind of a strong legal word, to prevent and to punish. So we're kind of on the hook there, right? And as I said in my opening remarks, it's clearly recognized that the obligations that arise under the Genocide Convention are of this nature of what's known as erga omnes, that all states owe those obligations jointly to each other, that there's this sense of a collective responsibility to uphold this kind of a convention. Canada has also criminalized genocide. That happened in 2000 when we were signing on to and getting ready to be part of the International Criminal Court. And the criminalization of genocide in Canadian law is not just the act of genocide. There's provisions in there about conspiring, attempting, being an accessory after the fact, counseling in relation to genocide. So there's a wide legal circle around what it means in criminal law. And then lastly, genocide, on top of the convention and the statutes, the prohibition on genocide is what's known in international law as a norm of customary international law. In fact, it's at the very highest level, something called jus cogens, which means you can never derogate from it. There's never any excuse for it. And why that's relevant in a Canadian context is customary international law is considered to automatically be part of Canada's domestic law, and that opens up all sorts of opportunities through which that customary norm can be used to ground legal cases, etc. So that's kind of a long prelude to kind of maybe a short response to the specific question. Yes, I think, given that we have this ruling from the ICJ, even before that, just the convention itself being there was reason to be legally concerned. But now we have the ICJ saying plausible genocide is underway, to use their language, in Gaza. So absolutely, decisions about arms transfers, decisions about curtailing UNRWA funding. I would say even the decisions that are being made about how to handle the evacuation of Canadians, how to deal with applications that are being made for refugee protection. any kind of government decision being made in this space right now, whether it's reactive or proactive, needs to be looked at very closely. Certainly within government, they better be getting very good legal advice, but outside government, I think there's lots of avenues for considering whether it's using the Genocide Convention and those legal norms as the hook or other kinds of human rights framing. I think there's a lot of potential.
Thank you, Alex. Genocide is so often reduced to a matter of killing and the numbers killed in ways that are challenged by the Genocide Convention itself, which lists many other acts that can constitute genocide, and by the provisional measures, which address other aspects of Israel's genocidal behavior, including through deprivation of humanitarian aid. Leilani, can you take us through the way that entire spectrum of atrocities that you described in your opening statement, and particularly in your own area of expertise, the destruction of homes and homelands, how that fits into a framework of genocide?
Sure, and I just want to be honest and clear that the law of conflict is not my area of expertise. The law related to the right to housing is. And so I come at this kind of fresh in a way, and I've had to think through painfully, actually, the relationship between homelands, housing, and genocide. And I do see a very direct relationship. I mean, under humanitarian law and human rights law, house demolition is strictly prohibited. I mean, strictly prohibited. Evictions, displacement, lots of different words are used depending on if you're in humanitarian law or if you're in the right to housing law, et cetera. So in that body of law, that the home is protected. And generally the reason is related to the relationship between home and life itself. Yeah, we all know what it is to live without a home. It is a fast track to death. Simple. One of the unique features of Gaza was that there was no homelessness in Gaza prior to October 7th. And that's a cultural distinction, actually. The close family ties, the way in which Palestinians would never allow someone to be homeless. Yeah, everyone has family somehow, somewhere. And so homelessness didn't exist. We're obviously in a very different position 118 days later. The link that I'm working on just conceptually and that I think is there is the relationship between home and one's ethnic or racial identity, home as an expression of one's ethnic or racial identity. And so the destruction of home being tantamount to an act of genocide. Yeah, because that's what genocide is the extermination of people based on their race or their ethnic origin or their ethnicity. And so it's just very clear to me that there is a very strong link. And I thought it might be nice or I don't know, nice, it's not the right word, appropriate, just to read a couple things. I've been collecting little testimonies from Instagram and Twitter of Palestinians and what they're saying about home. And every single Palestinian who is interviewed about their current conditions, if it's not the first thing, it's the second thing they say. They want to go home. They want their home. And they're talking about it in that big sense. They want their homelands, but they're also talking about it in that slightly more micro sense of their home. One woman said, and this was actually in a New York Times article that Michael brought to my attention, that my successor, Rapporteur on the right to housing, contributed to. But one woman said, "My kingdom has now been reduced to rubble under the Israeli airstrikes. I weep as I try to remember what I left behind when we were forced to leave. My camera catching happy family moments destroyed, the clothes purchased in preparation for the birth of my daughter, and my new winter coats all burned, my 3-year-old daughter's new doll lost forever. Someone else said, we are dying now because of the cold and rain. Our tents and our beds have sunk. We are now sitting under the rain and the wind with our children and our women. Use the expression. I swear to you, we are dying from the cold. And then one fellow was asked, what do you miss most about your home? This moved me so much. He said, relaxation on the couch, sitting together with the kids and my wife, and eating at the table. And those of you who know Palestinians, you know how important food is to identity. So, I mean, there is little doubt that that it is purposeful. It is, and that's actually not unique to this conflict. Homes are often the target in conflicts. I also just want to say that I think there's a very gendered nature to this. The home is associated with women. As feminist as you want to be, the home is associated with women. Social and economic rights are associated with women often. So I think there's also this sort of gender dimension to the genocidal act of demolishing homes. And I'll just leave it there.
I suppose also the fact that homes have been turned into a weapon of mass destruction against the families themselves who are inhabiting and sheltering in them and now are buried under the rubble, which accounts for the very high proportion of women and children who have been killed. Thank you, Leilani, for, I mean, I didn't know that there was no homelessness in Gaza before October 7th. I think that's such a beautiful thing to remind us of. So often the destruction of Gaza and reduction to rubble is represented as natural and normal. So thank you for reminding us that Gaza is also a place of home and a place of beauty. And what is settler colonialism except for the mass destruction and displacement of people from their homes? So thank you for that. I do want to make sure that we have enough time to hear from our other experts about the Canadian context, as well as to take on the other questions from the floor that we're not getting to in this moderated discussion. So we'll just do 2 more moderated questions, and then we'll hear from Danya, James, and Asaf, and then open it up completely. But also based on the questions from the Q&A, which are continuing to come in great numbers. Thank you, everyone, for sending them in. First, Michael and Alex, can we talk about some of the other processes in international legal institutions that are currently underway with respect to the situation in Palestine and Israel? There's another International Court of Justice advisory opinion on the illegality of the occupation, whether it has become illegal, as well as a current International Criminal Court investigation. So what's the relationship between this current International Court of Justice Gaza genocide case and those other international legal processes? And then, Alex, also, what is the relationship between the framework of genocide and other frameworks for understanding international legal violations, such as those of war crimes and crimes against humanity? And drawing on a question from the Q&A, does the framing of war crimes itself serve to obfuscate a situation of genocide? So we'll go to Michael and Alex, and feel free to also answer both of those questions. And then we'll end with a question about how we might deploy these on the ground, and then move to our discussion, particularly about the Canadian context. Michael and Alex.
Let me be very brief. And what I'll do, let me speak to the advisory opinion that's being put to the International Court of Justice next month. And I'll invite Alex to comment on the International Criminal Court. The General Assembly at the end of December 2022 adopted a resolution asking for an advisory opinion, an advisory legal opinion from the International Court of Justice. So this was instigated or inspired by Palestine. I'm proud to say that one of my reports, a special rapporteur in 2017, was on the issue of illegal occupation. And I think that helped provide some of the inspiration and some of the pillars that led to the request for an advisory opinion. So what the question next month in front of the court is this. Basically is the 56-year-old Israeli occupation still lawful under international law? There are certainly strands of international law which says an occupation once either it can be unlawful from the very inception, or it can be lawful but then turn into illegality. And that's the question being put to the court. And there are three arguments in essence that are being put to the International Court of Justice as to why the occupation has become illegal. The question is not being asked, was it illegal from 1967 onward? Number one, Israel as an occupying power has engaged in the unlawful and the de facto annexation of land. Annexation of land by an occupying power is a crime of aggression under the Rome Statute of 1998. Number two, Israel has denied the Palestinian right of self-determination. The right of self-determination itself is probably the first and foremost of human rights. It's Article number 1 in the two leading international covenants on international human rights, and it's been denied by Israel. And number 3, the argument is that Israel has instituted a regime of systematic discrimination in the occupied territories, which Palestine, which Namibia, which South Africa have all argued in front of the court in their written arguments last summer that this amounts to a regime of apartheid. 57 countries have issued written statements, and countries and organizations. That's the most ever for an advisory opinion being put to the International Court of Justice. So there's going to be argued over 6 days in late February, and we would expect a decision coming from the court sometime in June or July or August of 2024. It's certainly the hope of many who've been involved in this from near or far, that this will result in a resounding ruling on the fact that the occupation is illegal, and therefore the occupation should be ended immediately, and unconditionally and entirely, which would mean that Israel has to withdraw all of its settlements, all of its troops, and all of its presence right back to the pre-1967 boundary, and allow a Palestinian state to come. So that's the issue in front of the court. Certainly, the hope is that they can build upon the energy and the influence of the provisional measures ruling issued last week by the court. I should point out that unlike what happened 2 weeks ago, Israel is not going to go show up, at least is not expected to show up for arguments in front of the court. It issued I think a 5-page written statement back in July, basically saying Haig Schmeg, and is not going to wind up joining the proceedings. The United States will. The United States is not saying they're saying they're taking no position with respect to whether or not the occupation is legal or illegal. It's arguing, if I'm trying to keep a straight face with respect to this, you court should not rule on the substance of the questions being put to you by the General Assembly, because if you do so, you only will muck up the peace process, and we have to protect the peace process here. I'll let you decide how to wind up viewing that, but I think that, boy, that's a winning argument in my view. Anyways, Alex, over to you.
So the International Criminal Court is the other part of the question, and obviously, as I said in my opening remarks, the advent of the ICC, as it's known, agreed to in 1998, established and beginning to hear cases from 2002 onwards, was I mean, it's not without its imperfections and challenges by any means, but was a game changer in terms of the notions of international justice and tackling impunity. However, the ICC doesn't have jurisdiction over the whole world. The ICC only has jurisdiction over, so states ratify the Rome Statute, and from that, the court has jurisdiction over crimes committed on the territory of a country that has ratified, or by crimes that have been committed by the nationals of that country. It can also have jurisdiction if a country, even if it's not a party, accepts the jurisdiction of the court in a particular instance. And then fourth, it has jurisdiction if the UN Security Council decides to refer a case. Now, I'm sure it won't come as anyone's surprise, Israel is not a party, so there's no jurisdiction for the court that's going to be tied to Israel. But the state of Palestine is, even though the state of Palestine is not a full member of the United Nations, it does have the ability to sign on to international treaties and has done so with a number of human rights treaties as well. This is not the only time that the state of Palestine has done so, and it's not the only non-member state to do so. Not that there's any particular comparison, but the Vatican is another example of a state that is not a member of the UN, but does sign on to international treaties. So that suddenly gives the court jurisdiction, both obviously with respect to crimes, and the crimes that we're talking about when it comes to the International Criminal Court are genocide, crimes against humanity, and war crimes. There's also something called the crime of aggression. I won't go there. It's very complicated. Let's focus on those three, which are generally referred to as mass atrocity crimes. So any of those crimes that have happened in the state of Palestine, which certainly includes Gaza, any crimes that have been committed by nationals of the state of Palestine, and any crimes that have been committed from the state of Palestine. So the commission of the crime sort of begins or happens in the state of Palestine, even if the impact and consequences felt elsewhere. So there's the potential for extensive jurisdiction on the part of the court over really the entirety of what happens in Israel and Palestine. And so an investigation was launched. It was the prosecutor felt a little uncertain about, how solid was the grounds of jurisdiction. So they actually asked for an advance ruling from the court. And a number of states lined up on both sides of that equation, made public statements, made submissions to the court, including Canada. Canada objected to this notion that ratification by the state of Palestine was sufficient to give jurisdiction to the court. But the court ruled that it did have, that there is jurisdiction here and that the investigation can and should go ahead. That's all before October the 7th. So October the 7th comes along, and that only adds importance, relevance, and obviously urgency and gravity to that investigation. We've been hearing a lot from the prosecutor of the ICC, who's been to Israel, who's been to Rafah, is saying a lot of powerful things about the investigation being underway. But we've not yet seen any arrest warrants being issued, either for Israeli officials or for Hamas officials. There's kind of building pressure and expectation that needs to happen soon, especially given that many of these investigations were well developed before October the 7th. This isn't only about what has happened since then. So I guess really all we can say at this point is watch that space. And hopefully we're going to see something sooner than later.
Thank you, Alex and Michael, and thank you so much to all our legal experts so far for explaining things in such a clear and concise way. We know that one of the ways that law is used as an instrument of power is through its obfuscatory function, and you're doing so much to clarify and cut through that. So thank you. I'm just going to quickly respond to a question in the Q&A because there are questions about whether this session will be made available afterwards. And I think Karen can confirm in the chat, but that it will be available for viewing afterwards. And also, if we don't manage to get through all of your questions, perhaps you could, email them and we can come up with a Q&A document to address them if we don't manage to get through everything in our seminar today. And so finally, one last question to Leilani, Alex, and Michael before we turn to our speakers on the Canadian context. What, in your opinion, are the most effective and strategic ways we can deploy international law and international legal arguments in our advocacy here, particularly given the colonial, and this is inspired by questions in the Q&A, the colonial and white supremacist background and context of international law? Is it damaging in itself to buy into its premises? Or conversely, is it the global North's government's reactions to cases like the Gaza genocide case at the ICJ that diminishes international law? And so are there ways for us on the ground to effectively respond to that?
Let me try to answer that briefly.
Yeah.
Okay. I'm one of those who thinks that international law is a great ally, not only to lawyers, but to the civil society movement that looks for justice everywhere in the world, including in Palestine. So every system of law, be it international or domestic, always has this tension between law in the service of power and law in the service of justice. And there's a space, and I think a growing space for us to make these arguments in favor of justice within Canada and to make these arguments in favor of justice in the international system. And our role as lawyers and as those who support social justice movements is to push and expand that space in the international sphere, so that we rely upon human rights treaties and conventions. We rely upon rulings of courts and of the United Nations General Assembly and the Human Rights Council and the Security Council with respect to this. With respect to Palestine, there is no place in the modern world where international law has spoken so insistently, so clearly, with respect to the role of law and the necessity of justice as it has in Palestine. And obviously, the consequence, which we can all see, is this enormous daylight between promise and performance with respect to international law. That's no reason to be cynical with respect to the need or the necessity of international law. It just means we have to work that much harder, because international law, and particularly international human rights law, international humanitarian law, are our invaluable allies. You rest your case on law, and law is not only meant for lawyers, it's open to all of us. You have an impregnable case to be able to make in your advocacy with politicians, arguing in the mainstream media, and in forums like this.
Thank you, Michael. Leilani or Alex? Leilani.
Sure. I'm happy to weigh in on this. I completely agree with Michael's comments. The law is not the problem. It's the failure to implement. I actually think we are so lost without international law. And I think as consensus documents, I mean, after World War II, there was a global consensus that the way to have peaceful societies, good societies, equal societies, happy societies was through the implementation of a whole set of laws. And I would never want us to throw out the laws just simply because we have crappy governments who fail to do what they are legally obliged to do. I also think that our job, I mean, I've been an advocate all of my life, working life, well, probably before my working life. And, I'm constantly asking myself, what is my job? What is required of me as an advocate? I run an international human rights organization focused on housing. I feel I have responsibilities and obligations. I think my obligation and responsibility as an international organization is to breathe life into international law, to continue to insist upon it, because we're lost without it. And the situation in Gaza right now, and the situation for years now, 75 years in Palestine, is testament to how lost we are without it. So I guess I do have an unswerving commitment. That doesn't mean I haven't had exceptionally low moments in the last 115 days. I tell you, and I honestly, I was holding my breath during the entire ICJ hearing, because if that had gone awry, I don't know that I could have picked myself back up and to believe in the international international legal system. But we have the ICJ decision that is really beautiful. The whole thing is beautiful, from the submissions made by South Africa to their oral argumentation. I mean, I beg everyone, go back and listen to it. It's beautiful. And so we have it. And this goes back to an earlier question, but I feel like it has changed the tenor of a lot of advocacy. I mean, I keep my ear to the ground. I go to protests and marches and that ICJ decision has changed the way people are engaging what's happening right now. And I think it gave a bunch of us a little bit of a lift. We're going to keep going.
Thank you, Leilani. Michael and I were having a conversation with Palestinian human rights defender Noura Erakat the other day, and we were talking about how watching the decision, everyone kind of heaved a collective sigh of relief around the world that it was not nearly as bad as we feared it could be, which really also speaks to the collective investment in Palestinians and the stopping of the atrocities against them. Alex.
Be a third voice saying yes to international law with the same provisos and qualifications that Michael and Leilani have noted around the ways in which international law has let us down, that it's constantly undermined, that it's got its inherent limitations and weaknesses, but it's what we have, and it's full of such incredible promise. I mean, the words that were written back in 1948, et cetera, when this is getting underway, are exactly the vision of the world that Palestinians deserve, that we all crave, and the failures of international law to be able to deliver that aren't inherent in the law itself. It's a result of the failures of states to follow through. It's the implementation gap that's been noted. And there's just this incredible moment right now against a backdrop of such astounding tragedy, in which international law is in the spotlight like I've rarely seen it. The number of people on this planet who now know about the International Court of Justice, care about the International Court of Justice, and are ready to put their hopes in the hands of those 15 permanent, robed and very staid-looking but august legal experts is incredible. And so we do need to ride the wave that's come from that. As Leilani is saying, what was kind of unleashed or sparked collectively. Some of that will be law-based, and I think we're about to hear from some colleagues, for instance, around ways in which we can perhaps take this into Canadian courtrooms now and use innovative arguments, push the envelope, explore new strategies for legal consequences, even legal culpability, in perhaps ways that haven't been open to us previously. And then there's a whole host of ways in which this is broader than that, this is, since Friday, how many of us have heard, dozens and dozens of times now on evening broadcasts, in our social media channels, in conversations with a neighbor on this corner, did you know plausible genocide is unfolding in Gaza, with this sense of clarity and authority, which I think without that ruling, we just wouldn't have. That brings focus to the kinds of political discussions and processes we need to have. It gives focus to the collective action that needs to gather steam. And that's international law that's making that happen.
Thank you, Alex. Your comments reminded me of being at the International Court of Justice for the previous provisional measures hearing on the Rohingya genocide case, and the court being completely surprised at the media and public interest in the case. They were completely unprepared to deal with it, which speaks to the fact that it's used to being a court that adjudicates these very dry disputes about states, but in ways that aren't necessarily relevant to addressing some of the most severe violations and atrocities. So I think we all are saying thank you to South Africa for bringing this vital case. Now we're going to turn to some of our experts who can speak to initiatives on the ground to use these developments in international legal fora and elsewhere to pursue accountability for Canadian entities through Canadian law, and also to speak to the more general context of anti-Palestinian racism in Canada that is the context for all of these cases. And so we're going to start with Dania Majid of the Arab Canadian Lawyers Association. If you're ready to go, Dania, such a stalwart, and I don't like to say tireless because we all have a right to be tired, but you truly are just an unceasing, unflagging advocate and pursuer and worker for justice in these cases. You do so much of the labor on this. So thank you, Dania, for coming here tonight. I know you had other meetings tonight. Thank you for coming here and perhaps sharing with us some words about the context of anti-Palestinian racism that you elucidated in your recent report on the subject.
Thanks, Aziza, for that warm welcome, and to all the panelists. You guys are a hard act to follow. So I think I wanted just to start, before I get into sort of APR, the anti-Palestinian racism in the Canadian context, I did want to highlight that in doing this work and speaking about Gaza and international law, that we do not ignore what is happening in the West Bank. The atrocities there are escalating and are terrifying. So far, since October 7th, 400 Palestinians have been killed there by both the army and settlers, including extrajudicial killings, assassinations in hospitals. More than 6,300 Palestinians have been detained, tortured, starved in Israeli prisons. And Palestinian villages are being depopulated by settlers as well. Mobility is being restricted. The taxes needed to be paid for wages is being withheld. Schools are being closed and settlements are expanding. So we need to remember that what is happening in Gaza is, it is also connected to what is happening in the West Bank. This is part of the settler colonial project, and about seizing land without the people. So moving on to anti-Palestinian racism in the Canadian context, this is, we produced a report last year in 2022. We released a framework on anti-Palestinian racism to name it and outline how APR manifests in Canada and globally. And all this, the report and our online reporting tool, is all available on our website. So if you want to use it or read it in depth, it's all there, because I won't have time to get into it in detail. But in producing this report, one key element that we were thinking about and are most concerned about when speaking of APR is how it manifests at the institutional level, including governments, academia, and media. The report itself included a description of anti-Palestinian racism, which is a form of anti-Arab racism that silences, excludes, erases, stereotypes, defames, or dehumanizes Palestinians or their narratives. We noted that this can happen to both Palestinians and non-Palestinians who advocate on Palestine, and that anti-Palestinian racism cannot be conflated with Islamophobia. It is a completely separate form of racism, although there may be some intersectionalities with Islamophobia. So this report was created in order to have a tool that academics can use. We are now hearing a lot that it is being used in litigation cases to deal with a lot of the reprisals that we have been hearing about. We're hearing that both students and parents and activists and artists are bringing this framework into their spaces to push back against the censorship, the dehumanization, and the erasure of Palestinians and their narratives. And it is important that we continue to name that experience as anti-Palestinian racism. And if we don't call out this form of racism, then any proposed solution will not address the root causes of anti-Palestinian racism. So what we have been observing since October 7th is, in line with what we had written about it back in 2021, which, at that time reflected some of the experiences that we noted during the Unity uprising in May 2021 and the last attack on Gaza. But this time around, we are seeing it manifest itself in the most extreme ways by our government, mainstream media, and public and private institutions. So at the end of the day, like it's been quite universal that all levels of government have employed some form of anti-Palestinian racism in both their statements and their actions regarding Palestinian solidarity, and other elements, including, one could say their complicity in genocide based on some of the actions they have taken. So, for example, the Canadian government has relied on the dehumanization and smearing of Palestinians to paint them as a terror threat in order to provide Israel with the cover to commit their genocide and to not call for ceasefire. And we've seen Israel has deployed, as we heard in the earlier panel, they have deployed, very much this dehumanizing language towards Palestinians in order to, commit the, or as the rationale to commit the genocide. And Canada has gone along with that language. And in adopting that language, they have created they've devised our foreign policies on that basis. And we keep hearing them say, Israel has the right to self-defense. Well, they don't talk about that Palestinians were, under occupation for decades, and Gaza's been under a crippling siege. And at the end of the day, there is zero justification for genocide. But the impunity continues, and the smearing and dehumanization of Palestinians continue. And our history, our narratives, they're not only ignored, but we're even called anti-Semitic for trying to even raise our experiences and our history and our identities in having a discussion about what's happened since October 7th. And we've also seen anti-Palestinian racism employed in other issues, other domestic issues, like, for example, the racist requirements under the family reunification procedures that that's unrolled with the with the Minister of Immigration. Essentially treating anyone and everyone from Gaza as a terror threat. Asking for things no other immigrant or refugee population is asked for. For example, the description of every single scar on their body. Not even acknowledging that much of the data that needs to be collected is not available because everyone's homes are destroyed and everyone is displaced. And really, making the families here go through these really awful hoops in a race to save their family lives, because by filling out paperwork as quickly as possible, we have heard from these families about what an undignified the process was and how dehumanizing it was. And people in Canada, Canadians, were essentially crying as they were trying to fill out these forms for trying to save their family lives, and beat out another Palestinian family here trying to save their family life because there were only 100 spots made available. And again, it's in some ways it's almost a false hope because Palestinians can't even get out of Gaza, including the Canadians, those with Canadian citizenship. It's a false hope. And as this continues, Canada still does not call for a ceasefire. Then all the rhetoric we heard around the defunding of UNRWA, the main body supporting Palestinians in Gaza. And not only, was this, they made this announcement, but they made it on the day of the ICJ ruling, about, of the provisional measure order, which one of those measures included the provision of aid to Gaza. And that was the day Canada decided to, again, smear UNRWA as a terrorist organization, and claim that they're going to be pausing or halting funding to UNRWA. Now, they have sort of weaseled their language around that a little bit to say, well, actually, the money's already gone to UNRWA. So they're talking about future funding that's being paused. But it doesn't really matter, because at the end of the day, they have put the smear out that the UN is, the main UN agency in Gaza is a supporter of terrorism. And this reflects the Israeli line and sort of really kind of, subjects, opens the attack to UNRWA from either this government or, future governments that may be elected. And again, it's that repeated trope that Palestinians, it's the justifications there. They're terrorists. They justify punishment. And while all these measures are happening, nothing has happened. No sanctions, no embargo has been implemented towards Gaza, towards Israel. We are still sending our arms to Israel in the midst of genocide, so on and so forth. The smearing continues to solidarity activists, which is also very concerning. So the federal government, provincial, municipal, all of them have essentially come out and labeled protests and any sort of activism around the genocide as pro-Hamas rallies. And also, when they say pro-Hamas rallies, they also point out that Hamas is a terror group in Canada, which, is a separate panel about our terrorism laws. But again, it's smearing pro-Palestinians as supporters of terror and making that linkage. The scary thing is we have seen in cities like Toronto, this language has now been weaponized by our Toronto police force, who are not only over-policing protesters, but they're actually using the hate crimes unit to commit essentially guns and gangs raids on protesters in the middle of the night and treating them as terrorists. They're being surveilled, arrested in front of their family members. But, the charges essentially are mischief. And when have we seen anyone charged with mischief treated like Canada's most wanted? And they have spent upwards of $7.5 million in covering 4 months of protest and demanding more funds for more surveillance, which is funds that are really desperately needed for housing and transit and other essential services. The Ontario Ministry of Attorney General has created an attestation policy to ask new hires from a particular law school if they signed an open letter in support of Palestinians as a condition of hiring. Again, this is unprecedented. This is blatantly a form of discrimination, but the Ministry of Attorney General is getting away with this. And when our governments have mainstreamed these spears and dehumanization of Palestinians and their allies and adopted these tactics, they have essentially opened the door for the public and private sector, including employers, to then discipline and fire workers in support of Palestinian rights. And we at the Arab Canadian Lawyers Association and our colleagues have been inundated with messages from workers who are being fired or disciplined for posting something as simple as ceasefire now. As a result, we have created a Palestinian and employee rights guide to help people navigate this minefield, and that too is also available on our website. And again, we are seeing not only just Palestinians attacked, but we're also seeing our allies being attacked. For example, the Art Gallery of Ontario lost 3 Indigenous curators because of their support on Palestine. So we need to keep doing our work and keep pushing forward. We cannot let this demobilize us or discourage us, but we need to keep the APR, the Anti-Palestinian Racism Framework, in our analysis, call it out in our work, push back against the erasure of APR and our so-called diversity workplaces or the measures at our workplaces. And as social justice movements, we must see our work as connected with other movements who are also experiencing similar forms of oppression. And the last note I want to end, which might be counterintuitive for most on this panel or attending today, is that law isn't the answer or the solution. It's a tactic in mobilization. But at the end of the day, if we want to affect change, whether it be in government or media or other institutions, it is on the ground mobilizing adopting, calling for arms embargoes or ban on settlement products and services, boycott, divestment, sanctions, and so on. It is that mobilization that will push the government and our courts to do the right thing, but they will not do it without that push. So I'll leave it there.
Thank you, Danya, for all your work and for so clearly breaking down the logic of anti-Palestinian racism that makes the Palestine exception to freedom of expression, freedom of assembly seem natural and logical and legal, so that it even becomes protesting the genocide that becomes represented as the injury, not the genocide itself. For those of you who are as outraged by this unconscionable defunding of UNRWA, as I know many of us on the panel here are, there is a mass online global rally planned for tomorrow at noon EST with speakers including our very own here on the panel with us, Michael Lynk, as well as many other eminent speakers who have all come together in a very quick period of time to protest this outrageous decision, including people like Gayatri Spivak, Michael Hart, Noura Erakat, Susan Abdulhawa, and many other very prominent academic and political and activist figures. So please do join us for that tomorrow online. Now to speak more concretely about law as a tactic in mobilization, we turn to two lawyers who have really been at the forefront of strategically using the law to challenge this entrenched impunity that Alex and our other speakers spoke about when it comes to Israel's violations against Palestinians. James Yap, and then we'll hear from Asaf Rashid. James.
Yeah, thanks, Aziza. I'm going to start by echoing what Danya said about how law is not the answer. I think that's absolutely right, especially in the circumstances. In this circumstance, in this situation, it's clear that the path to victory is political. The path to victory is organizing, is mobilizing. Law is a complement to that. Law can support that. Law can do a lot of incredible things, but it's really plays a supporting role, I think, in this particular struggle. So I'm going to talk about the so everything that the first three panelists said about the ICJ case under the Genocide Convention. I'm going to sort of relate that to legal action that can be taken in Canada, specifically with respect to the arms trade, because at the same time as Canada is cutting off humanitarian assistance to UNRWA for vague and unproven allegations, it is continuing military assistance to Israel, which has time and again in a widespread and systematic institutional level manner been demonstrably committing war crimes and other atrocities. So that continued export of arms to Israel is illegal. I'm going to explain why. As Alex and others have said, the Genocide Convention is unique among international treaties in that it's not only an obligation not to commit genocide, but also to prevent genocide. States undertake an obligation to prevent genocide when they enter into the Genocide Convention, as Canada has been a party for was it 70 years. So that obligation to prevent genocide is triggered by the existence of a serious risk of genocide. The ICJ has concluded that there is a serious risk of genocide here. So that obligation to prevent genocide is engaged. What does that obligation entail? Not entirely clear, not entirely settled, but it seems pretty clear, I think, that obligation entails, at the very least, not providing arms to the country that is at risk of committing genocide, so to speak. And under international law, there is a treaty called the Arms Trade Treaty, which prohibits, to which Canada is also party, which prohibits the export of arms to a country where there's a serious risk that those arms could be used to commit not just genocide, but any kind of international crime, war crimes, crimes against humanity, for example. That arms trade treaty has been incorporated into domestic statute under the Export and Import Permits Act. And so basically under law, both domestic and international, it's unlawful for Canada to approve exports of arms to a country where there's a serious risk those arms could be used to commit a serious violation of either international human rights law or international humanitarian law. That's law. It's absolute. It's not anything, like, oh, the government should consider these factors, whatever. It's just the government shall not approve these export permits if there's a risk of serious violations of international law. The Canadian government has been very evasive about what arms have been going to Israel since October 7th. At first, they were just dodging the question completely. Then they've just tried a bunch of tactics to kind of like lawyer around it in not a very effective way. At first, they'd say, "Oh, we aren't providing arms to Israel. Canada, the government, is providing arms to Israel," which was never the question. The question was whether they were allowing exports from Canadian companies, okay, to go to Israel. Then they would say things like, "Oh, well, we're not selling any full weapon systems to Israel, but again, that was also another question because Canada, if you look at what it delivers to Israel, and there are some NGOs that have done some great work researching this, Will Beyond Wars, Project Plowshares, we don't deliver full weapon systems. We never have. We deliver components, right? And now they're saying, oh, we're delivering non-lethal. There's no export permits issued for lethal weapons to Israel. But non-lethal weapons, first of all, there's no clear definition that they've given of what that is. And non-lethal weapons can always, you need a lot more than just a pile of missiles or a pile of bullets to conduct a war and commit war crimes. Non-lethal weapons can always be integrated into lethal weapon systems or just integrated into military operations that are committing war crimes. And there's a reason they're called weapons. There's a reason they're classified as arms, and the export of these items or technology is controlled under the law. So they continue to be very evasive about that. What can be done? So we wrote a letter along with Al-Haq, a Palestinian human rights organization, as well as some Palestinians living here in Gaza. We wrote a letter to Minister Joly. I put the link in the chat. It's very detailed. It's about almost 50 pages, but it's very thorough. Okay, it sets out everything that's happened or in Gaza since October 7th. It says, Minister Joly, this is what's happened. This is why this is all unlawful under international law. It sets out the law saying, you can't export arms in these situations. It then sets out, what we do know about what kinds of weapons have gone to Israel in the past. And then it says, Minister Joly, for these reasons, the issuance of export permits for arms to Israel is an illegal activity. We demand that you stop it, and take these measures, etc., to stop it. Okay. And we've given them 14 days to respond. The letter was sent on Sunday, so those 14 days are ticking. And we'll see what happens. If they do not give us a satisfactory response, we will consider all our options, legal or otherwise. One thing I want, so that is a sort of developing story to sort of, I guess, follow if you're interested. One thing I want to add is that one of the things that we want to do is get evidence directly from people in Gaza who have been witnesses to atrocities and bring it to Canadian courts. It's possible right now to do things technologically that weren't possible 10, even 5 years ago. You know, you have smartphones, and I mean, smartphones have been around for a long time, but it's got to a stage where they're almost universal now, and everyone, practically everyone on the globe, you know, has a smartphone or knows someone who has a smartphone. Once you have a smartphone, you can download WhatsApp, and you can get it on a video call. Okay. On top of that, since the pandemic, lawyers in Canada have been able to commission affidavits remotely. So before, you know, when we take an affidavit, you know, we'd have to sit down face to face with somebody and say, you know, do you swear that the information in this affidavit is true? Now we can do that over a video conference. So that means, in theory, we can take evidence from someone anywhere in the world, including Gaza. So what we want to do and what we're going to have happen is in the the next round of like litigation that's coming, and believe me, there's litigation coming, whether it's this or not. The legal left has taken a while to get mobilized. It's true, but we are organized. We do have a lot of strength, and we will be bringing these issues to court. When we do, what I envision is coming with evidence from Palestinians who are in Gaza talking about the atrocities that they witnessed. And if we, it's very hard. Okay, like, yes, the technology is technically available, but we've been trying. It's been very difficult. I'll be honest, I'm not sure we'll be able to do it, but I'm optimistic. I think we can. And if we do, then, I mean, for the first time, we'll be able to bring the voices of Palestinians in Gaza. We'll have these voices heard in Canadian courts, echoing throughout a Canadian courtroom. And that is, I think, is going to be profound. I think it's really going to be revolutionary if we can pull that off. I'll end there.
Thank you so much, James, for that update from the legal front lines and the possibilities of using developments in both law and technology to resist and contest the genocidal colonial erasure of Palestinians in Canadian courts. Now, Asaf will hear from our third legal expert on the Canadian context, and then we'll wrap up with some questions and from the floor and final comments. Asaf.
Thank you. I think I'll be the shortest of everyone here. So I'm just going to echo what others have said as far as where social change comes from. My background before becoming a lawyer was a labor organizer, and working class people didn't follow the law followed them. And it's the same thing with other social movements. The law follows social movements. It follows the pulse of what's happening on the ground. So I'm a lawyer based in Halifax, Nova Scotia. Chibuktuk is the Mi'kmaq name, the non-colonial name of where I live. I'm part of the International Center of Justice for Palestinians Canada. And amongst our objectives is to promote justice and the protection of human rights for Palestinians in Canada and beyond. Allies with Israel must be held accountable, unquestionably. Israel gets its strength from chiefly the US, but from other allies, including Canada, that continue to be complicit in Israel's war crimes and genocide. So the International Center of Justice for Palestinians, we're in the early days of our organization. We're affiliated with the very well-established International Center of Justice for Palestinians based in the UK, who has sought war crimes proceedings against UK officials for complicity of them in Israel's war crimes. On November the 16th, ICJP Canada issued a notice of intent to seek prosecution of Canadian officials for war crimes. And the notice was served on Prime Minister Trudeau, Minister of Foreign Affairs, Melanie Joly, Minister of National Revenue, Mary-Claude Bibeau, and Minister of Justice and Attorney General Farha. We, not surprisingly, received no response to this day. And on November 16th, we held a press conference. There was a lot of views of it. Of course, the Canadian government officials were served. They're aware, but they did not respond. No surprise. At the time, on November the 16th, we flagged key areas of Canadian complicity with Israel's war crimes. And one of them has already been very well versed by James. on the issue of Canada allowing arms to be traded to Israel while Israel's engaged in war crimes, and now a plausible case of genocide. And of course, that is illegal, as James already pointed out. There's also recruitment of Canadians into the Israeli military that happens. It's not supposed to happen. It's against the Foreign Enlistment Act, but it happens. And that's another issue that's raised in our notice. There's also allowing so-called charities to subsidize Israel's armed forces and incentivize the participation of Canadians in the Israeli military, and as well so-called charitable funds going to expand Israeli settlements. Charities are not supposed to do this kind of thing, otherwise they're supposed to lose their charitable status, but they have been doing it. In the case of this kind of support for Israel's military, it defies the law, as it happens in so many other cases in Canada. And another issue we raised as well in our notice is moral support and encouragement for Israel's war crimes. Canada has not condemned Israel's war crimes, not in any way that it ought to have. It's been very vague about anything it's said about what Israel's doing, and then out of the other side of its mouth, it's encouraging Israel. We did flag also at the time in our notice the risk of Canada being complicit in genocide, and now with the worsened state of affairs in for Palestinian people in Gaza and the West Bank, and South Africa's ICJ case of a genocide against Israel and Provisional Measures Order, Canada faces possible violation of the Genocide Convention and the ICJ order, as I think has already been very well covered. We're factoring this into our next steps. So we're really in the midst of planning our next steps and are presently coordinating with like-minded lawyers to build support for each other's efforts and bring matters to court in Canada and beyond. And a lot of the work that we're doing now is to build on our infrastructure so we can do the research required and the work required to move forward to the next steps. We're also going to be exploring the issue of Canada having suspended funding to UNRWA as contributing to violation of the order for Israel to effectively facilitate humanitarian aid into Gaza. Canada diverting funds of up to 40 million to a number of other organizations, such as the World Food Program and the International Committee of the Red Cross. While they're great organizations, they absolutely cannot replace UNRWA in the least. UNRWA has 13,000 staff on the ground in Gaza. They have experience there. They've been there for such a long time, infrastructure to deliver aid en masse. To attempt to try to go around them with other organizations, as good as those organizations are, will be a huge lag time, and Palestinian people in Gaza do not have that time. So, like I said, I'd be very brief, and those are really my comments just about what is coming on the horizon. There'll be a lot more updates as we keep building our efforts, but thanks.
Thank you so much, Asaf, for those trenchant comments and for bringing this case. All of our legal experts have been so excellent here tonight, and I think we've answered already in the course of your remarks many of the questions in the chat. A common theme emerging across all of your presentations has been how exceptionally well documented Israel's long history of violations are, whether through the reports of people like Michael Lynk as UN Special Rapporteur, or in South Africa's 84-page submission to the ICJ, or in the applications that James and Asaf have been bringing to courts, whether international or domestic. And then on the other hand, the silencing and stonewalling that is deployed by governments like Canada in order to simply render these facts and factual documentation illegible, resorting to, as we've heard so often throughout this panel, to what can only be called in the accurate philosophical term, legal bullshit. As Henry Frankfurt said, bullshit is not simply an effort to contradict the truth like lies, but is actually even more damaging to the truth because it seeks to make the truth simply irrelevant altogether. And so in the face of all of this legal bullshit, our profoundest thanks to all of you for all the work that you've been doing. Now, we do have some remaining questions in the chat that sort of fall into several clusters. So I'm just going to put these 3 clusters to all of you, and then we can just do a round of final comments, and you can respond to what you like within the questions, as well as any final remarks that you would like to make, being mindful of time too, because I know we've held your time for a very lengthy duration here tonight. Oh, wait, actually, before we move on, for James and maybe also for Asaf, there were just a couple of quick questions about how people can support your cases. For example, can people send videos they've acquired from social media? And also, what's the best way to reach out if they believe they might be of help in getting witnesses? So if you can just quickly answer those, and then we'll go to the final round.
Okay, yeah, thanks for that. I am. Oh, did I put that link in the chat earlier? Did I manage anyway? That's the link to the letter I was mentioning. And if you're interested in helping out, just send an email to that email address, and we'll sort it out.
Okay, thank you. Thank you so much, James, and thank you to everyone in the audience who's so willing to help these legal initiatives go forward. And so now let's maybe try and wrap up by addressing some of the outstanding questions from the Q&A. So first, there are several questions or clarifications regarding the International Court of Justice decision itself. For example, was there some legal reason why the court could not explicitly order a ceasefire, even if it has ordered a ceasefire, perhaps in another name? Does the fact that it refers to Israel's obligation to quote unquote prevent genocide serve to obscure the fact that genocide is already occurring by making it sound like something that's just a prospective future rather than an actualized reality? And can South Africa continue to go back to the court if they are unsatisfied with the way that the situation continues to develop? So there's that cluster of questions about the International Court of Justice decision, which I think Michael will take. And then we have some questions that are more related to international humanitarian law, sort of a grotesque euphemism for the laws of war. So first, does Israel as an occupying power in the Palestinian territories actually have this right to self-defense that we continuously hear it invoke, and that we hear allied governments continue to invoke? And what is Palestinians' right of resistance in response to the occupation? And then third, we have several, so perhaps Alex can take that. Alex? And then third, we have several questions about the specific entities that can be held accountable, invoking international law, but perhaps in domestic courts. So we've heard about Asaf's and James's efforts to hold government entities accountable, and how that also implicates other organizations like charities, for example, but or arms trade corporations. But can those charities, corporations, and also other civil society advocacy organizations directly be held to account for their complicity and participation in genocide? So whoever wants to address each question, I think we have an idea who can do it, but we'll just go do one last go around, and please address the questions and anything else that you would like to say before we wrap up. And let's start with Michael Lynk.
You're asking me to be efficient. Let me try to see if I can answer this really quickly. The question is, if as is happening, Israel is not obeying the legally binding order of the International Court of Justice. It's saying that it is, but it's continuing as before. There is no appeal. The court decision is not only legally binding; it's final. This now transfers to the United Nations Security Council, as I had mentioned before. So that's where the spotlight now is, and that's where probably that diplomacy is going to be. I understand that the U.S. has given early indications that it would veto a new ceasefire resolution. In many ways, I hope the ceasefire resolution gets before the Council very quickly, and if the United States feels compelled to do it again, well, let history be the judge. With respect to the United States' actions. Otherwise, it's going to have to be civil society. Civil society has to see itself as the new superpower in the world in terms of, I guess, demanding from below that there be arms trade with Israel ends, that there be restrictions or withdrawals of trade agreements, that diplomatic relations be rethought. I mean, how is it that we have UNRWA having its funding suspended immediately based on the fact that 0.1% of its employees in Gaza are alleged to be members of or have participated with Hamas, when Israel, where the court has found a plausible case of genocide, no action is being asked for by the global North with respect to diplomatic relations, trade relations, and arms shipments. Please, someone help explain that to me.
Leilani, you have the explanation?
There is no explanation. I mean, there is this new form of governance that has emerged recently across the Western nations, and it's called governance by hypocrisy. That's clear. They're taking it to an art. Actually, it's become an art, this hypocrisy. I just wanted to say on the ruling, the ICJ ruling, and this issue about, well, they haven't really decided on genocide. Well, come on. I mean, what they said was that there is a plausible case of genocide, that the acts that are being undertaken plausibly constitute genocide. I mean, that's a lot for us to work with as advocates, for sure. And the court was clear, and Michael, provided us such an amazing summary. Thank you, Michael. I'm indebted. I needed that summary. That they have to stop genocidal acts, right? I mean, that is huge. So just that I think that we should use that and use it for all its strength. The only other thing I'll say is on the second question, which we haven't gotten to, but then I'm not gonna say anything more on the right to self-defense. There have been some really beautiful statements about this by other people far more eloquent than me. The current special rapporteur, Albanese, has made many comments to the Australian Press Corps, for example, about Israel's right to self-defense. And I also note Zomlot, who is the Palestinian rep to the United Kingdom, on the BBC just recently. Just look it up. I mean, his answer to that was I thought it was brilliant. That's it for me.
Thank you so much, Leilani. Let's do Danya, Asaf, James, and Alex, and I'm purely just going by the order in which you appear on my screen. It's completely arbitrary. So, Danya.
I mean, I don't really know if I have much more to add than what was already expressed by all the panelists. But yeah, I just think we got to keep organizing and pushing, and amplifying and speaking, because we just can't let them literally get away with murder. And we do have to hold, use the different ways, different mechanisms to hold our government to account. And we have to keep in mind that there's an election around the corner. I think the time is now to start thinking about that election, how we're going to mobilize, and really what are the options that we have before us. Because I mean, the one thing is that Israel is a bipartisan issue. Both the liberal government and the conservative government are both really awful on it. So I think we just we have to think forward in terms of what's to come, and how we're going to make that change here at home.
Preach, sister. Okay, Asaf.
Well, I think it's great seeing this many people coming together, and that things are getting very organized at a legal level, of taking Canada to task, taking various institutions and companies to Canada to task. And I think this will play out, that there will be an impact to this when different officials as well as entities in Canada, like those who are involved in the production of arms, etc., dealing with things at a level of piece by piece, things can be taken apart as far as the infrastructure for supporting Israeli war crimes, supporting the apartheid regime. Because as was mentioned, it's the West Bank too, not just Gaza. That we have to look at all of it, and I do have confidence that we're going to pick away, and especially with this swelling of support of people that are not going to stop being in solidarity with Palestine. We're going to be effective.
From your mouth to God's ears, inshallah. James.
Inshallah.
Yeah, I don't have a lot to add to what's been said over the last 2 hours, but one thing I do want to say is, particularly for those of us on this call who are lawyers, I just want to put out there that we really got to get together and figure out who's going to challenge this UNRWA decision. because I think it strikes me as something that needs to be challenged. It needs its own challenge. It's I haven't looked into the law on this, but it really strikes me as really suspect, this decision, and I can't see how it could possibly be legal. I've been begging people over the last couple of days, like other colleagues of mine, can you do this? Can you do this? I can't, unfortunately, because I'm doing other things, but there's got to be someone out there who can bring that challenge. So let's figure out who that is.
Okay, so Zoom meeting next week.
All right, let's do it.
Yeah, let's do it. Okay, Alex.
Yeah, I too think that the substance has been well covered. I was going to make the same suggestion Leilani did to look at what Francesca Albanese has been saying about this whole self-defense thing, because she powerfully takes it apart. And I too was also going to really reaffirm that what the ICJ has said about genocide is so significant. I know the language may kind of let us down to a certain degree, but that was the question in front of them. The question in front of them wasn't, has genocide happened? The question in front of them, which they answered overwhelmingly yes, was, is it plausible that genocide is underway? And to have that in the public record right now is an incredibly powerful tool for us to use in courtrooms, in conversations with our neighbors, in how we talk to our MP, everywhere. And so don't worry that it somehow feels like it has diluted the arguments. I think it's really given us incredible wind in our sails. And I guess I would just end by saying this has been an incredible evening. It's amazing to see so many people on the call. And I know I'm going to draw energy from that, because certainly going forward, that's what we need. We need to find that everywhere we can. It's out there. There's incredible solidarity. There's amazing mobilizing like never before. And let's just make sure we're just not relenting. Have as many conversations as you can every single day with anyone who will listen, starting from your MP to your neighbor and everyone else. Aren't you concerned about the genocide in Gaza, and what are you doing about it? We need to keep that up, and I think we will prevail.
Thank you, Alex. Leilani, did you want to say something else, or you're good?
Yeah, sure.
I think
Free Palestine, end the occupation.
free
Ceasefire.
Palestine, ceasefire now. Yes, and everyone, please come to the rally tomorrow if you're able, to fund UNRWA, defund genocide. Thank you so much to all of our speakers here today. Over the last 100-something days, we've seen the power of international lawyers to contort themselves to justify what should be abhorrently unjustifiable. We've seen even very fine legal minds splitting hairs to say that, in fact, Israel does have a quote-unquote right to self-defense in genociding Palestinians, to represent these evacuation orders, a mechanism of forcible transfer, as being somehow a good faith application of international humanitarian law and a humanitarian effort to warn Palestinians. We've seen the capacity of lawyers to justify the unjustifiable, but today here we also see the power of lawyers and international legal argument to be an international law from below, an international law in defense of the dispossessed, the genocided, those who have been excluded from international legal institutions. So profoundest thanks to all of our speakers here today. The webinar will be made available for anyone who would like to review this and go over the finer points of international law discussed here today. But I think this was such a powerful session. Greatest thanks to all of you. Thanks to our host, Just Peace Advocates and Canadian Foreign Policy Institute for hosting and organizing this very vital discussion. Good night to all of you.
Bravo for steering us, Aziza.